So I'm delighted to be back in Kosovo for the first time for about 15 years. And I'd like to thank the organisers for inviting me and for the excellent organisation. So I'll be talking today about the interplay between politics, the law, and justice, and the consequences for the many victims and survivors of the ex-Yugoslav wars. I'm focusing mainly on the early days of the ICTY and the UN Commission of Experts that preceded it, because the obstacles that they found recur in varying forms throughout the ICTY's existence and beyond, often affecting indictments, sentencing, court proceedings, and arguably its overall reputation. The ICTY was established in early '93 and closed its doors in 2017. Officials at the Tribunal's final legacy conference in 2017 claimed success. And to some extent, they were right to. The ICTY has made a substantial contribution to international criminal law and, amongst other things, to providing an extensive archive for other ad hoc tribunals. But what of the victims? Those who died, over 130,000 of them, and the many who continue to suffer the consequences of wars that were arguably preventable. Have they received justice? Has the ICTY fulfilled its mandate? And what about the politicians and diplomats who presided over international policy in the 1990s wars? Did they do everything possible to ensure adherence to international laws and conventions? Did they act to prevent genocide? So I'm starting with Bosnia. Widespread crimes against humanity were officially recorded as early as the 14th of April, 1992, but they were not made public. The information came in the form of a classified memorandum to the US Secretary of State, Lawrence Eagleberger, from a member of his department, Thomas Niles, which described the Serbs, and I quote, clear pattern of use of force, intimidation, and provocation to violence aimed at forcibly partitioning Bosnia and effecting large transfers of population. This was April '92. And UNHCR and the International Red Cross also knew of violations of international humanitarian law from at least May '92, but didn't report them. It was only following British and US journalists' graphic exposure of the camps in August '92 that more serious measures were considered to quell the public outcry for something to be done, and that included an international tribunal. An extensive Helsinki Watch report based on 2 trips between the 19th of March and the 19th of June '92 confirmed the journalists' reports. It alleged that the scope and brutality of abuses far exceeded those reported, and considered that systematic executions, forcible expulsions, and shelling attacks offered prima facie evidence of genocide in progress, and called on the UN to ensure those engaging in genocide be held accountable, stressing that the UN, through the Security Council, was under an obligation to prevent genocide in Bosnia. By autumn '92, women's and human rights groups had joined with media to present a chilling picture of rapes, expulsions, and detentions. Initially, there was considerable reluctance internationally for a tribunal which would have the power to indict the very people whose cooperation was relied on in the international peace process. So as an interim measure, the UN Security Council established what they called a commission of experts, with the mandate giving it the broadest international investigative authority since the UN War Crimes Commission of World War II. But the commission was beset by obstacles from the outset. It was denied access to adequate funding and essential resources. There was no office to work in, no personnel, no translators, and no computers. Ralph Zachlin, the deputy UN legal counsel, was tasked with presenting options for the establishment of the tribunal, but it was a curious choice, for Zachlin was later to observe that, and I quote, a landmark of a particularly dubious kind was reached, when the Security Council decided to create an international criminal tribunal for the former Yugoslavia. The crucial lack of financing meant that personnel could only be recruited on short-term contracts, considerably narrowing the choice. Technical equipment needed to start investigations couldn't be purchased, nor could a formal lease for premises be entered into. There were also the overwhelming practical difficulties of collecting evidence in an ongoing war, where the priority was the protection of UN troops on the ground. And disagreements soon emerged amongst the major world powers, particularly between the US and Britain, over the Commission's name, its mandate, and who should chair it. British officials proved particularly obstructive. Having curbed the power of the Commission of Experts, the British delegation, although superficially endorsing the tribunal, began to undermine it behind the scenes from the outset. In March 1993, Britain submitted a confidential non-paper to the UN Secretariat questioning the Security Council's authority to set up the tribunal. It argued that the cardinal principles of international law were not always clear and should be omitted from the tribunal statute. The first principle denied immunity from prosecution to heads of state. Britain also attacked the second principle, which does not allow individuals to escape responsibility by claiming that they acted under the orders of a superior. A central difficulty faced by the Commission and also later by the Tribunal was the refusal of leading international players to recognize the true nature of war, the war in Bosnia, and to act on it. Instead, major world powers, Britain, France, and Russia in particular, all permanent 5 members of the UN Security Council, continued to characterize the conflict merely as a civil war. This assumption of equivalence of guilt deflected from the responsibility of the Milosevic regime. It allayed public concern while facilitating ongoing negotiations with the main perpetrators, and in particular Slobodan Milosevic. The appointment of Tadeusz Mazowiecki was one of these special rapporteur for human rights. It was one of the few positive international measures to emerge at the time. But he was also impeded by lack of funds, denied resources for field officers, and shunned for exceeding his mandate. In July 1995, after Srebrenica, Mazowiecki resigned, considering himself to be little more than a stenographer of horror. He criticized the UN relief agencies and peace negotiators, commenting that human rights agencies appeared to be at odds with the tribunal and peace at odds with human rights. The tribunal's early difficulties echoed those of the Commission of Experts. With no funding or resources, the elected judges prepared to go home and wait until the tribunal was more fully established. As one judge commented, they had no officers, no statutes, no prison, no accused, no logistics, and not even a prosecutor. Okay. In November 1993, Antonio Cassese was elected president of the tribunal. Unlike many of the judges, Cassese viewed the tribunal as a precursor to an international criminal court and was prepared to confront the politicians. Initially, he believed in the political will of international leaders. Later, he was to call himself naive. It wasn't until June 1994 that a chief prosecutor was agreed on. This meant that the objectives and penal strategy could not be defined, blocking the way to indictments and prosecution. This impasse was finally broken with the appointment of Richard Goldstone, who finally, on the 25th of July 1995, brought indictments against Karadzic and Mladic for genocide and crimes against humanity in the municipalities in 1992, and he issued warrants for their arrest. So this could have been a turning point in the tribunal's fortunes, but it wasn't. The fact that Milosevic himself had not also been indicted contributed to the misconception that he was a suitable negotiating partner at international level. His flouting of the arrest warrants issued by the ICTY reinforced his apparent exemption from international sanction. On November 7th, 1995, JN officers Milan Mrkšić, Miroslav Radic, and Veselin Slivančanin were indicted for the mass killing of 264 non-Serbs removed by force from Vukovar hospital, later executed and buried in a mass grave at Ovčara. Ironically, had the tribunal played a major role in the Dayton negotiations, as its establishment under Chapter 7 of the UN Charter implied it should have, the Vukovar indictments could have had a radical impact on future developments, since the crimes were committed under Milosevic's watch. I'd be interested to hear what the floor has to say about that. David Owen, Lord David Owen, the EU envoy to former Yugoslavia till June 1995, didn't see it that way, and he later outlined his Realpolitik governing international thinking. And I quote, "When I met Goldstone, I explained the detail of the negotiations and showed him the difficulties. The conclusion that they could easily draw was that it would not be very wise to indict the heads of state if we wanted to arrive at a negotiated peace between them and with them. I believe that Goldstone and Arbour had this pragmatic attitude, this judgment of good sense, and that the tribunal only indicted Milosevic when the prosecutor understood that he was no longer an obstacle politically, because after Kosovo, there was no more means to negotiate with Milosevic." On the 16th of November, Mladic and Karadzic were again indicted for genocide, this time in Srebrenica. But despite two genocide indictments, there was no mention of the tribunal in the General Framework Agreement at Dayton. Instead, it was relegated to the annexes, which were not signed by international heads of state. So no responsibility internationally. Carl Bildt later noted, "The Serbs didn't want any mention of the tribunal in the framework agreement, a battle which they eventually won in a direct session with Christopher, the US Secretary of State at the time. The tribunal disappeared from the text," said Carl Bildt, "to be replaced by a general reference to international undertakings." At President Clinton's news conference following Dayton, his only direct reference to indicted war criminals was that they would be excluded from political life. The month after Dayton, Warren Christopher announced, quote, "It is not part of the NATO obligation nor part of IFOR's responsibility to hunt down or to seek out war criminals. That is not part of NATO's mission." The IFOR commander, Admiral Leighton Smith, went further still. During a live call-in on Parley Television on the 18th of January 1996, he made it clear that he intended to take a minimalist approach to all aspects of implementation apart from the protection of his forces, that he didn't have the authority to arrest anybody, and that NATO would not guarantee security for tribunal teams investigating the grave sites. By the end of February 1996, over 50 individuals had been indicted by the ICTY, yet only one was in The Hague, and he had been transferred from Germany. Politicians later indicted by the ICTY continued to occupy leading positions in post-Dayton Bosnia, including Momčilo Krajisnik, Biljana Plavšić, and Jadranko Prlić, while Karadzic continued to control all Republika Srpska central institutions from behind the scenes. Leading up to the Bosnian elections in 1996, OSCE Chairman Flavio Cotti, reiterating concerns over lack of cooperation with the tribunal, already expressed by other organizations, warned of, quote, "the most serious danger that they would generate into a pseudo-democratic legitimization of extreme nationalist power structures and ethnic cleansing." So his words were prescient, but they fell on deaf ears. At the 54-nation Dayton Implementation Conference in London in December 1996, the tribunal was only included after considerable pressure from Kasese, but as mere observers, not participants. Reference to states' obligation to cooperate with the tribunal in arresting indictees was erased in the communiqué. On 24th July 1996, the British Foreign Secretary Douglas Hurd and Foreign Office Political Director Pauline Neville-Jones visited Milosevic in Belgrade, where a $10 million deal was signed between Serbia and NatWest markets to assist in privatizing Serbian telecom. This was to prove crucial to funding the Kosovo War 2 years later. In late 1997, there were rumors that Milosevic might be fomenting a violent confrontation in Kosovo, creating a crisis that would distract from the Serbian Zajedno protests and allow him to declare martial law. The culture of impunity that prevailed after Dayton resulted in a missed opportunity to bring the main perpetrators to justice and to prevent another Balkans war. Now to Kosovo. Throughout the 1990s, Kosovo Albanians endured repression. Human rights abuse became legalized. There was discrimination in health and education. As Albanians were purged from their positions, journalists persecuted. The Albanian language radio and television station was closed. A new Serbian curriculum was introduced in schools. In January and March 1998, Human Rights Watch recorded 83 killed in the Drenica area, including 18 women and 10 children. It was a watershed, and that month the Tribunal Prosecutor's Office stated publicly that the tribunal was empowered to prosecute persons responsible for violating international humanitarian law since 1991, including in Kosovo. Tribunal delegations visited Belgrade, but throughout 1998, the Serbian authorities denied access to ICTY investigators to investigate war crimes in Kosovo. And this was to prove crucial to later developments, eventually leading to the establishment of the specialist chambers. In mid-May 1998, Milosevic conducted a scorched earth offensive along the border with Albania with impunity, looting, then destroying towns and villages. In Ljubenic, a number were summarily executed by the Serbian Special Police, and by September 1998, over 250,000 had been displaced, according to UNHCR. There was a KLA counteroffensive in July 1998 in Orahovic, but the Serbian police recaptured the town within 2 days and 42 people lost their lives. So around 2,000 lives were estimated lost in 1998. And there's a couple of booklets here, one by Amnesty International and one by Human Rights Watch. And they were both published in September and October 1998. And they detail all the crimes that were committed by 98, well before the 1999 indictments. So my question is, why were only Kosovo Albanians indicted for war crimes during that year? The Ratchak massacre in 15th of January 1999, verified by the KVM, brought the situation back to international notice. Yet, as the International Crisis Group pointed out, US and European policymakers are repeating in Kosovo many of the same mistakes they made before, during, and after the wars in Croatia and Bosnia. After neglecting the Kosovo issue for nearly a decade, they only began considering it when large numbers of dead Albanians began appearing on their television screens. International peace talks opened at Rambouillet the following month in a last-ditch attempt to avoid NATO action. They came to nothing, but they did allow time for the Serbian authorities to develop extensive plans for a large spring offensive. So who was indicted for all those crimes? Well, several Yugoslav army generals were finally indicted in September 2003, and in 2009 were sentenced to up to 22 years imprisonment. Yet Milan Milutinovic was acquitted. During the entire period covered by the indictment, Milutinovic held the position of President of Serbia and a member of the Supreme Defense Council, involved in decisions concerning the deployment of armed forces. He organized the preparations for the defense of Serbia, and as a member of the SDC, he held authority over those units of the MUP, the Interior Ministry, responsible for Kosovo, which was subordinate to the Yugoslav army whenever there was war or risk of war. So the decision to acquit him was puzzling to many. That said, the prosecution could arguably have presented a better case. It called no witnesses on constitutional law issues to combat the testimony of Ratko Markovic, the Serbian deputy prime minister at the time, and a heavyweight with some 40 years' experience in constitutional law. And it may also be significant that all defendants were indicted under Articles 7, 1, and 3 of the ICTY statute for individual criminal responsibility, but had the indictment included Article 7.2, the prosecution might have stood a better chance of conviction. The Haradinaj trial arguably altered the course of Kosovo's political development at a crucial time in its history. Within weeks of his election as Prime Minister, Haradinaj was indicted by the ICTY and voluntarily surrendered to the tribunal to defend himself in what was to become a landmark trial and retrial spanning over 7 years. During his brief term in office, Haradinaj had impressed senior international officials, especially over his endeavour to build bridges between the Serbian and Albanian communities. And his indictment was criticised by a number of leaders with whom he had come into close contact, including Søren Jensen Petersen, the Danish head of UNMIK, former KFOR Commander General Klaus Reinhardt, and the then British Foreign Secretary Robin Cook, who commented that Kosovo had made more progress under Haradinaj on key standards such as minority rights and conditions for the return of Serb refugees than anyone in the previous 5 years. Carole Del Ponte, the chief prosecutor, attempted to characterize Haradinaj in her indictment as a senior figure responsible for serious violations of international humanitarian law. He was certainly a senior figure, but he was by no means a serious offender. The case was poorly put together and fell apart at the trial. Relying heavily on Serbian sources, it was a misguided attempt to prosecute even-handedly, irrespective of the scale of crimes committed. And on the part of the Serbian authorities, it was a bid to rewrite history and minimize the true measure of responsibility for the crimes. In partial mitigation of Del Ponte, it should just be mentioned that early on she did work hard at international level to secure the arrests of main indictees, but met firm in position and was even reprimanded, according to her memoirs, by senior politicians and diplomats, including the US Ambassador William Montgomery, Kofi Annan, and even Madeleine Albright. It was after she failed in this that she cut a deal with Belgrade, and Haradinaj was the sacrificial lamb. Although, I guess for anyone who knows the man, it's a totally misleading metaphor. So, where are we now? Milosevic died in his cell at The Hague. Karadzic and Mladic are still at Scheveningen. Almost 25 years after indictment, neither has experienced as much as a day of normal prison life. Nebojša Pavkovic and others convicted by the tribunal have had books published. Biljana Plavšić, having had her genocide indictment commuted and her sentence drastically reduced, recanted her guilty plea in her memoirs. Vladimir Lazarevic was invited to lecture at the Serbian Military Academy. And Vojislav Šešelj, sentenced on appeal to just 10 years, he had already served at The Hague, is a member of the Serbian Assembly, appears weekly on Pink and other TV channels in Serbia, but boasting of how he has beaten the ICTY. His stand, apparently at the recent Belgrade Book Fair, was the most visited. People convicted by the tribunal for the most grievous crimes against humanity, having served 2/3 of their sentences, have returned to Bosnia, in many cases to taunt their victims. Serbian nationalists continue with revisionism and genocide denial, but nationalists in Bosnia and Croatia also continue to deny proven facts. In the Šešelj trial, witnesses were bullied, even abused with impunity, by one of the most serious offenders of the Bosnian War. He was initially acquitted by majority. The second judge brought in just weeks before judgment was due to be pronounced. Judge Niang, the substitute judge, had little or no courtroom experience. He was not present at any of the trial, and he had only about 4 months to study a case lasting 9 years. While Frederick Harhoff, who sat on the bench throughout the trial, was suspended following a published letter criticizing recent judgments, and his name removed from the ICTY website. Florence Hartmann, a different case, but also exposing tribunal shortcomings, was actually imprisoned for speaking out. In the Karadzic trial, judges even reprimanded witnesses, witnesses who had experienced horrendous crimes for not answering often totally irrelevant and sometimes personal questions from Karadzic, and some of them would have threatened the witnesses' safety. So I'm nearly finishing. The final legacy conference was intended as an assessment of the ICTY's work, but the obstacles it faced at international level were not referred to once, as far as I could tell, over several days' discussion. And when a few speakers from the floor attempted to describe current conditions in Bosnia, where survivors are bullied by convicted war criminals returning home after relatively short sentences, and this on a daily basis, their interventions were dismissed. So the tribunal accomplished a lot, but it did mess up at times. And it was not independent. It was in the hands of the UN Security Council, and the Permanent Five in particular, and answerable to them, not to the victims, whose voices were increasingly less audible as the years passed. And finally, just a word about a worrying development at the mechanism that succeeded the tribunal. Through a series of serpentine maneuvers, a judge who apparently dissented in the Tolemir genocide conviction has been appointed as presiding judge in the Mladic appeal case to replace Meron, who with two other judges was removed for alleged bias based on previous judgments. The judge who effected Meron's replacement, the senior judge at the mechanism, Jean-Claude Antonetti of Shechel infamy, also dissented in the Tolemir appeal. So what will the new presiding judge do? She may recant, but if she chooses to maintain her position in Tolemir, she will acquit Mladic on either some or all of the charges. Leave it there. Okay, thank you.